You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host with today's Subrogation Support Network podcast. We have a really fascinating topic we're going to discuss. We're going to talk about cannabis law and related regulations, insurance issues, concerns regarding the claims adjusters may touch on, just different things we're kind of seeing out there. And a lot of our topics are kind of bland, kind of dry, but frankly, this one is really topical and it's relevant today, and it's really just a fascinating topic. I've gone to a number of claims events, NASP, CLM, different groups, and it's been a topic of interest for the last 5 years or so, because, I mean, there's been just so many disparities on the different states' rules and the states versus the federal government and everything we're seeing. Beyond that, Illinois, south of us, and I'm here in the land of beer and cheese of Wisconsin. But south of us in Illinois, they recently legalized recreational use of marijuana. And I can tell you now, you used to be driving from where I live in Lake Geneva to Chicago, and it would be all plaintiff's attorneys and personal injury signs. Now it's like 50-50 personal injury attorneys and dispensaries. So it's a huge thing out there. We're seeing it day to day, and it's going to be a fun topic. So Sally Bruck is here to join me, an attorney here with our Hartford, Wisconsin office. Sally, how are you doing today?
Good, Ashton. How are you?
Excellent. Well, thank you for joining me. Thanks for coming up with a great topic. So a lot of times in these conversations, I do a lot of the talking, but here I think Sally's really done a lot of research and has an interest in this issue. So it's going to be really more of me asking questions and us going back and forth a bit. So Sally, let's start with tell us a bit about yourself and what you're doing here with the firm at MWL.
Sure, Ashton. And thank you for inviting me to do this. I'm an attorney here at MWL in Hartford, Wisconsin. I practice in the areas of insurance subrogation, insurance defense, and insurance coverage.
Excellent. And now, what about this topic really kind of got you interested? Is there something about cannabis law, cannabis litigation that made you think, hey, this would be something that I want to learn more about?
Well, several years ago, I attended a seminar put on through DRI, the Defense Research Institute for Insurance Defense in Chicago, and very comprehensive, and sparked my interest in continuing to keep up on the topic. It is one that's changing, and it's expected to be a significant area of work for insurance defense attorneys as well as for carriers as the law changes, not only in the states, the various states where cannabis has been legalized, but also what will happen if legality changes on the federal level. And that's really the big question right now.
And for the listeners today, I think today's topic is going to be more focused on insurance issues, right? But also not totally subrogation related, though it's going to have a subrogation impact. We're going to see, I've already had claims involving cannabis and related issues. And frankly, there's often coverage disputes underlying those. But starting with the first question I have for you, Sally, the market for insurance products for cannabis related business, from everything I hear, it's expected to increase in size, and it has increased hugely over the last several years. Can you give us an idea of how large the market may be going forward in the cannabis space?
Well, according to various market researchers, by 2026, the U.S. cannabis market, in terms of national sales, may reach $42 billion. And U.S. cannabis firms, by that date, are expected to account for 75% of the global market share. So quite large.
Interesting. And I'm sure we'll touch on it, but I know some of the big stuff with that is when you have this increasing scale and you have this unique divide between something that's federally illegal and something state by state are becoming recreationally legal. You have situations where a lot of times, and I'm sure you'll touch on this, Sally, there's no insurance options or limited insurance options, or the options have extremely I mean, the coverage limitations are huge. I mean, a lot of these, dispensaries, they can't even bank through normal banking systems, right? They have to go with the, safe in the back and, because a lot of these banks are federally mandated, so
That's
they can't even put their money there, right? I mean, it's a crazy kind of Wild West world we're in right now.
that's right. It
So
is.
before we go into that stuff, I want to just, since this is new to a lot of people and frankly, largely new to me, let's go through some of the terminology that applies. Can you give us an overview of the different type of cannabis we're talking about in the US and where and which type may be legal?
Sure. Um, the hemp plant and the cannabis plant, those are two terms that probably everybody has heard, hemp and cannabis, are actually varieties of the same plant species, which has got the Latin name Cannabis sativa, sativa, for those of you that are interested in that detail. So let me break that down. Cannabis is also known as marijuana, and it contains substances within it called cannabinoids. And those are further broken down by something called cannabidiol, which we've probably all heard of as CBD. And this is the non-psychoactive component of cannabis. It's an anti-inflammatory chemical component. And interestingly, it can be derived from both the hemp plant and the cannabis plant. And it's currently legal fully or conditionally in 47 of the 50 states. So that's the first product that is a significant product in cannabis. The second one has a fancy name, Delta-9 tetrahydrocannabinol. And we're all familiar with that, mostly by the abbreviation THC. THC is the psychoactive substance associated with cannabis. And as far as psychoactive, from the science standpoint, it releases a substance called dopamine in the brain, which creates that euphoria effect that most of us have probably have heard about. THC is fully legal for recreational and medical use in 24 states now, and it's fully legal for medical use in 38 states. And finally, hemp, to distinguish that from cannabis, contains both CBD and THC, but by definition, it has to contain less than 0.3%, 0.3% of THC. And hemp is currently legal in all 50 states under the 2018 Federal Farm Bill.
Interesting. So obviously we've now kind of touched on the lower overview, kind of the general terms. Now let's talk about like the high view of this, right? The higher issues. And that's just me wanting to toss in, a little, cannabis pun there. But all right, now let's talk about this. So is cannabis legal? Like, where is it legal? Is it legal in all 50 states? I think is the question. Where is what's the breakdown now? Because things are changing, right? Every year, or at least every few months, you hear about more and more states legalizing. I think there's a difference between obviously CBD, these oils. I mean, they're legal pretty much everywhere, as you said. Delta-9, THC, I think it's legal for recreational or medical use in 24 states, right? I think it's kind of an or there because we mentioned 24 states. I don't think it's that weed is legal in 24 states, you mean, but more and more states are starting to embrace this. Walk me through that a little bit. What's the current status of the law? What are we seeing as things move forward?
Sure. CBD, which we've just talked about, that's the non-psychoactive chemical component, is legal either fully or conditionally in 47 of the 50 states. And THC, which is the psychoactive substance that we talked about, is fully legal for recreational and medical use in 24 states and fully legal for medical use in 38 states.
Now, getting to the questions of where cannabis is legal, are the laws pretty much static or the same, or does it kind of really differ state by state in how the law related to legalization of cannabis, THC, CBD is applied?
Well, that's where there are some vast differences, and that everybody needs to be um, familiar with for their state and for other states. Each state defines what is legal in that state. For example, CBD oil may only be legal to 0.5% THC, and THC or marijuana may only be legal to 1 ounce. Really, what carriers need to do, as well as insurance subrogation lawyers, is to consult each state's laws. Right now, there is just no uniformity.
And as this expands, we might need to make another MWL 50 state survey on that issue. So we're always looking for more of those. But all right, so state laws, everything's different. Now let's get into the federal law, right? And I think that's where things, rubber hits the road and things get really interesting and complex. Walk me through the current legality for cannabis under federal law in the United States.
Sure, Ashton. Yes, it is illegal under federal law, specifically the Controlled Substances Act, abbreviated the CSA. It's in 21 U.S. Code Section 802 and the following sections, and that has been the law in our country since 1970, when it was signed into law by President Richard Nixon. So it's been the law for a very long time.
And it's my understanding that the law almost has marijuana in similarly situated to, like heroin or methamphetamine. I mean, different things. I mean, I think those would be Schedule II drugs. I mean, it's kind of fascinating. I mean, the world's kind of changing in that regards, right? In that, people are kind of differentiating and realizing maybe there's a lesser effect, but not to get political on it, but kind of walk me through where it's at now. I mean, have there been any changes since Richard Nixon signed this into law in the 70s?
Yes, there have been several changes. Significantly, in 2018, the federal Farm Bill removed hemp from the list of Schedule I controlled substances. The DEA, which is the Drug Enforcement Agency, which is the agency that governs these classifications, does not consider hemp-derived cannabinoids with less than 0.3% THC or less to be a controlled substance. So as long as hemp is 0.3 or less THC, it is not a controlled substance. It's removed from the list of Schedule I. But currently, Schedule I is still where cannabis is located, and that makes it illegal, puts it in the same category as heroin, as you mentioned, Ashton, and classifies it as even more harmful than fentanyl and methamphetamine. Schedule III drugs are illegal and considered to be the least harmful of the scheduled substances, like Tylenol with codeine is an example. So currently, it's illegal. It's still a Schedule I. But we've seen some changes. For example, in December of 2022, President Biden signed the Medical Marijuana and Cannabidiol Research Expansion Act. And the reason for that, according to that bill, was to expedite scientific application for cannabis producers, including universities, to grow cannabis for scientific research. So public opinion, I think, as you've mentioned, favors scientific research. And we've seen that happen as far as December 2022.
So on a federal level, nobody's now going to come out and arrest me for using my hemp rope on my garden or whatever I'm using it for. And also they've really touched on kind of the medical side and medical marijuana and the use and legality in a way for research. Now, any recent changes or current proposals going forward on the federal level?
Yes, it's not legal for medical on the federal level yet, but many states, as we mentioned, have made it legal for medical. 38 states out of the 50, in fact. But yes, there have been some changes, some initiatives, if you want to call them that. In October of 2022, President Biden also issued an executive order asking the U.S. Department of Health and Human Services, HSS, and the Attorney General to re-examine cannabis's Schedule I status under the Controlled Substances Act. And since then, several things have happened. It hasn't been reclassified yet, so it's currently, as it's been since 1970, an illegal Schedule I drug. But in August 2023, just last year, the Department of Health and Human Services recommended that cannabis be reclassified from Schedule I to Schedule III. And that would make cannabis legal, putting it in the same category as, say, Tylenol with codeine. Then, later in 2023, in December, the U.S. Drug Enforcement Agency, the DEA, announced that it had started its own review, but not yet made a recommendation. So the outcome of that is far from certain, and under federal law, the DEA would have, quote, the final word. In January of 2024, 11 U.S. senators wrote to the Attorney General and the DEA, urging them to swiftly deschedule cannabis from the Controlled Substances Act. In other words, they went even farther than the HSS recommendation to make it a Schedule I. These senators are saying it should be completely removed from the schedule altogether. There's been no response to that request, though, within the statutory deadline to respond. So that apparently has not been considered.
And it's really interesting. I mean, at least my basic understanding is, there's a lot of reasons why the federal government would want to, or there needs to be some sort of consistency. Right. I mean, obviously, the general idea of federalism is the states can, they can legislate some things, but the federal government has supremacy over different issues. I mean, ultimately, this would be one of those issues where, they're not being in line is creating a lot of concerns. And I think a lot of times, they're not really, at least correct me if I'm wrong, actively prosecuting these things. They're pushing hard on the states. But the way that this is impacting people is just that. It's these companies, these individuals, small businesses who are operating cannabis-related businesses in those states where it is legal for either one, recreational, or two, medical usage. They're not being able to operate a business effectively because they're currently, and not just out of compliance, but they're currently involved in a criminal enterprise in a way under federal law. What are some of the reasons that you've heard behind these proposed changes? Is it to kind of get that in line, or what is the federal government looking at here?
Well, a hint to that is in that recent letter by the 11 U.S. senators, just from January 30th of this year. They argue that current law is, quote, out of step with the state laws and public opinion. And they also cite the negative impact of the current federal cannabis policy on ordinary people and small businesses. And like you mentioned, Ashton, that includes the difficulty of small businesses to operate in states where the states have legalized cannabis for either medical or recreational or both.
And this is unique when you look at it because a lot of times either the federal government's going to come down with their heavy hand and make clear to the states that this can't happen, or two, they're going to change their rules and they're going to go along with what the states are doing and defer to the state's ability to proceed with these things. But right now we're in this kind of limbo area, it sounds like, where nobody really knows where it's going to go. I mean, is the federal government going to become more lax, right? Or are they going to, at some point, become more aggressive and actually maybe not prosecuting, but pushing back on the states on, legalization and so forth. So just getting back into, what they're considering. They're considering a move to classify cannabis as a Schedule 3, right? Schedule 3 narcotic or whatever it would be. If that's the case, what happens? What does that mean?
Well, there'd be a number of important implications for insurance carriers and cannabis-related businesses. There is a report by the Congressional Research Service uh, that can be found online that sees major federal policy implications for cannabis-related businesses. First, it would be lawful nationwide for businesses now to manufacture, distribute, and dispense cannabis, uh, not only in their own state, but as to all states and possibly interstate. And it would also be legal for individuals to purchase and possess cannabis. Individual states' medical cannabis laws would need to comply with federal law going forward, including federal public health laws, agricultural marketing laws, and things like that. It's anticipated the FDA oversight would increase over cannabis products and that they would apply federal food and drug regulatory standards to it. And then finally, medical research on cannabis might increase or is anticipated to increase due to the less strict regulatory controls that apply to a Schedule III drug as compared to the current Schedule I classification for cannabis.
Thanks, Sally. I mean, that's a really in-depth, and I appreciate the background because I really didn't know all of this stuff about kind of what's going on behind the scenes. But now let's kind of take that general view and let's apply it a little bit more towards the insurance industry and just these businesses in general. So my understanding that there is pending legislation, the Claim Act, which would be, it's also, it's the clarifying law around insurance of marijuana. It was brought forward in 2021. Tell me a little bit about Claim and how, if enacted or considered, it would impact insurance carriers that are insuring cannabis-related businesses.
Yes, this act, abbreviated as the Claim Act, appropriately, proposes that admitted carriers would be able to serve cannabis-related businesses without the threat of federal prosecution. First, it would provide a safe harbor from penalties and other adverse agency action for insurance companies that provide insurance services to cannabis-related legitimate businesses in states where cannabis-related businesses are legal. The Claim Act also requires the Government Accountability Office to report on barriers to marketplace entry for minority-owned and women-owned cannabis-related businesses, as it likely would for other types of businesses or marketplaces that it already governs. And then the insurance underwriter claims processor would need to first look to whether a cannabis business is in compliance with local, state, and federal regulations. So a lot of changes, but this act would make it legal for carriers to serve cannabis businesses.
And we briefly touched on it, Sally, but I think for the audience, it's important to note, right, that the big issue here, and frankly, the reason why we're talking about this is most insurance companies, those who write throughout the country, right, the big names, or pretty much almost anyone out there, it is not legal to write most coverages for these companies who are engaged in the sale or production of cannabis in the states, even if it's in states where it is recreationally or medically legal and available. Most coverages aren't available, just like banking, right? Am I correct in that, Sally?
Yes. And, perhaps the best answer to that is if we skip down to some other challenges facing the insurance carriers. I'll just touch on that briefly, and then we can go back to where we were. Because cannabis is still illegal on the federal level, most existing commercial policy forms exclude any cannabis-related activity. And appropriately, it's not legal. Currently, insurers generally have to modify their existing policies by adding endorsements to accommodate each individual state's cannabis laws in states where cannabis is legal. And the Insurance Services Office, ISO, does currently offer several endorsements that either exclude or provide coverage for cannabis-related risks that insurers can employ in states where it's either legal or illegal. But there's many challenges still facing carriers as far as figuring out what they can insure, where they can insure it, and what policy forms to use.
Interesting. Right. And that's kind of my understanding. Now, is there any other proposed legislation as we're trying to wrap that part up to figure out, I mean, how the federal government can create that consistency or build a system where these businesses operating legally in a state can still get the coverage or the banking that they need?
Yes, there's three pieces of legislation that are waiting in the wings, so to speak, for the DEA determination if it does reschedule cannabis to make it legal as a Schedule III drug. One of those is called the SAFE, S-A-F-E Banking Act. It was introduced back in 2017. It's still pending, and it proposes to legalize and regulate banking nationwide for the cannabis industry. And if it's passed, it's anticipated the CLAIM Act, the clarifying law around insurance of marijuana, may or would be passed with it. In fact, in 2021, the National Association of Insurance Commissioners submitted a letter in support of the Safe Banking Act.
And I can say one thing to add on that is, I recall speaking with an insured once who was involved in an industry like this, and they kind of outlined how it worked for them to even get a loan from the bank. And one, they just couldn't even put their money in it. So, I mean, it was difficult to even process transactions because processing through Visa, MasterCard, different credit card companies, there were issues. Putting money in a bank, difficult to even put money in a savings account legally. And then that gets even more complex where let's say you want to, get a mortgage on a property or take out a line of credit to be able to operate your business. But for working with very small regional or local banks, and even in those situations, there's federal regulations that impact them. It's almost impossible under the current environment, as I understand it. But I'll digress and go back to you, Sally.
Yes, that's correct. And as far as additional legislation that's also pending in the wings, so to speak, there's two more things. The MORE Act, M-O-R-E, stands for Marijuana Opportunity Reinvestment and Expungement of 2021 when it was introduced. That's the decriminalization bill that would afford Congress, once the DEA acts, to decriminalize cannabis and remove it as a Scheduled I substances or completely from the list of scheduled substances under the Controlled Substance Act. It proposes to eliminate all criminal penalties for individuals or businesses who manufacture, distribute, or possess cannabis, and would also retroactively release and expunge persons convicted of nonviolent cannabis crimes under current federal law. The last one is the Cannabis Administration and Opportunity, CAOA, and States Reform Act of 2021. This one is pending and interestingly, this one establishes a structure for federal regulation that would be very similar to the existing regulation as it is for alcohol and tobacco. And it would also let the states take the lead on cannabis regulation.
Interesting. All right. Now that we've gone into that, let's get more into just the businesses in general that we're talking about, right? Walk me through the types of cannabis-related businesses that we're talking about that have these issues and these risks for insurance and for banking and so forth.
Well, the way that the insurance industry looks at it, and again, this was from a National Association of Insurance Commissioners white paper from 2023, the cannabis businesses are broken down as to what products and services they provide, quote, from seed to market. So that's an interesting way to look at it, from seed to market. So first of all, we have cultivation, which is both outdoor growers and indoor greenhouse growers. Now, federal crop insurance is not available. It is available for hemp under the 2018 Farm Bill. And In some states, under specific requirements for licensing, if the particular business has a prior history of successful crop production, if they have current contracts for purchase of whatever hemp crop they produce, they may be insurable under the 2018 federal farm bill. Private crop insurance is generally not available because there's a really small market, a lack of data, and a lack of experience in claims. So then moving on to the next step in the ladder from seed to market is processing and manufacturing. And so for this category, we look at consumer packaged goods such as edibles, inhalable products as examples of that. And insurance risks related to these businesses would be similar really to any other business. It would, the risks include inventory of high value raw materials, the risk of contamination during processing and manufacturing that could make the product unsaleable, mishandling of production waste that violates state laws, and then more traditional insurance policy coverages such as fire and theft. Moving on up the ladder, testing. So professional liability insurance and errors and omissions insurance, it's anticipated these would be needed for companies that test the raw materials and the finished products. They would be testing for things like pesticides and other contaminants and compliance with state law sanitary rules and regulations for an inhalable or edible product. Next would be distribution. And again, here, you're looking at things like raw materials as well as the finished product, and you're looking at transportation of both, consumer delivery. Both would require cargo coverage for theft, hijacking, and spoilage, as well as traditional auto liability commercial coverages. Retailers, just like other retailers, they would need coverage for premises, property, and general liability, inventory, employee benefits, employee practices liability insurance, business income and interruption, umbrella coverages, commercial auto, and cybersecurity, in addition to state-mandated workers' compensation coverages. And then as to all businesses in the supply chain, product liability insurance, it's anticipated would be needed to provide coverage for defects in design, which could be contamination, defects in manufacturing, which could be contamination, warnings about consumption, dosage, packaging defects that might not be child resistant. And it would be needed for all entities in the supply chain, the cultivator, the tester, the manufacturer, the distributor, and the retailer.
So this is a ton of different businesses and different entities, issues that could be at play. And obviously, as we all know, being in the insurance industry, any business operating needs to make sure they're appropriately covered. And I think that's the big problem here. You mentioned there being new ISO forms and different endorsements that can be included. But as we discussed, I think because cannabis is still legal on a federal level, it's my understanding that most commercial policy forms just are going to outright exclude cannabis-related activities. So, I mean, if these businesses are going to, and I've actually seen this a number of times, where they go to their local agent, the local agent writes a policy for some other type of business, that they give them an auto policy or something else, just general commercial liability. And next thing you know, they have a claim and it's denied because, it could be that their grow lights, right? The grow lights caused a fire or something else came into play, and then they're out of luck. What other challenges are you seeing facing these carriers? And, what can those businesses do different? What can the carriers do different to make sure that they are appropriately writing the coverages that are needed in this current environment, assuming that the insurance carriers are interested in getting into that business?
Yes, and those are excellent questions because these challenges to insuring cannabis-related businesses are a great concern. There are numerous challenges to claims handling. as well as writing policies. Traditional policies may not sufficiently address the unique risks to the cannabis industry. And as you mentioned, there aren't standardized insurance policies with uniform language, definitions, and exclusions. And as we mentioned earlier, most existing commercial policy forms exclude cannabis-related activities because of the illegality that still exists on the federal level. So insurers are left to adding endorsements that comply with each individual state's cannabis laws. And as mentioned, the Insurance Services Office, ISO, does offer several endorsements that can be used to either exclude or provide for various cannabis-related risks. But as mentioned, there's no standard policy with uniform language, definitions, and exclusions.
And the example I brought up would be, let's say that grow light caused a fire, and that was a grow light used to grow cannabis in a state where it's legal for, let's say, recreational or medical purposes. Would that be a scenario wherein, if it was just a standard policy, that could be excluded?
That is the concern. And carriers that provide cannabis-related businesses with insurance are generally, and skipping down here to the next topic, are generally excess and surplus lines market carriers. Those are able to do that because they're exempt from state regulations and law. But it's really unknown the degree to which that's going on because it's difficult, apparently, for state insurance regulators to get data on availability, affordability, the extent of insurance coverage for cannabis businesses in each state.
Right. Now, is there anything going forward? I mean, it sounds like a lot of carriers are moving to kind of specialize, right? Where there's now a specialized group of carriers, be it surplus or however they're situated, that are handling and writing these coverages. What's needed going forward, and what do we see as kind of the future state here? I guess assuming no change to federal law.
Well, and that's the current situation that insurance carriers find themselves in. What can be provided under the current state of the law, given cannabis is still federally illegal, and we have a patchwork of different state laws that have to be complied with. Only a few states, according to the National Association of Insurance Commissioners, have admitted carriers, and they are typically in selected lines that are required by state laws, such as workers' compensation coverage. The interesting thing is the state of California Department of Insurance has developed an insurance policy package or has adopted an insurance policy package that was developed for it by AAIS, which they call Canna BOP. It's a package policy with liability and property coverage for qualified cannabis dispensaries, storage facilities, distributors, processors, manufacturers, and private cannabis testing facilities and laboratories. So we already do have an example that has been produced and apparently utilized in the state of California.
Interesting. Well, it sounds like things are, moving, but moving slowly. A lot of the proposals were in the 2021 timeframe. Around then, things are moving in a direction. But I'd be fascinated to kind of see how things play out. It sounds like we're still stuck in this kind of limbo position on coverage. So I definitely encourage all listeners, if you have a case involving cannabis and any excluded coverages, anything there, get with good coverage counsel in the specific state. But ultimately, the subrogation aspect, we're seeing just as more and more businesses are getting into this field, you're going to see more and more cases that involve in some way cannabis-related claims and entities. I've seen cases come through involving just last year one where it was a dispute over it was a fully legal CBD shipment. that actually happened to have higher levels of THC than was legal and was acceptable for the client. So they rejected the load, and it was claimed by consignee. The company had the product shipped to them, and the company producing, the manufacturer of the CBD and THC oils. So there's definitely going to be more claims involving these issues. I'm really fascinated to see how they come. So Sally, I'd love to have you on in, a year from now to kind of see what's changed, if anything has. But anything else you want to add before we wrap this up today?
Just briefly, we talked about standardized policies, and it's anticipated that if Congress passes the pending legislation and the federal government declassifies cannabis to a Schedule III drugs, that we would see that happening. There would be a more uniform insurance product. Either the Insurance Services Office, ISO, or the American Association of Insurance Services, AIS, or both, which advise the insurance industry, would develop standardized policies for carriers so that commercial cannabis operations from seed to market would have appropriate coverages. But we have to wait and see, as you said, Ashton.
Well, Sally, thank you. It's a fascinating topic. Hope to have you on, sometime soon on this and other topics. But thank you so much for joining me today. It's been a pleasure.
Thank you, Ashton. It's been a real pleasure. Thank you for the opportunity.
And to the audience, as always, thanks for listening in. This is Ashton Kirsch signing off with today's episode of the Subrogation Support Network podcast. Until next time.